Hey everybody, good morning. It's Mahoney. Tuesday tip, sometimes Wednesdays. It's early in the morning. I'm over in my Rockford office. I had a deposition in Rockford this morning, so last night I was getting ready for the deposition. I thought I would talk to you today about slip and fall cases and what to do with regards to insurance specifically, because this happens a lot now. We're in January and February here in Northern Illinois, so typically you got snow and ice, although we don't have that much. And people slip and fall a lot in parking lots and on sidewalks and on that type of thing. So if you've seen my other videos, you see that generally speaking, you have no liability for natural accumulations of snow and ice. So that means if the snow and ice is naturally there and you slip and fall, the property owner doesn't have any liability for that. If the property owner decides to remove the snow and ice, they got to do it in a reasonable manner. So if they do it in a manner that creates a bad condition, then they could be responsible for that. Here's the long and the short of it that you need to know in case you have an issue. If you fall somewhere and you get injured, typically what happens is the owner of that property or the manager of that property comes out, and like any human, they're very sympathetic, and they tell you, don't worry, we'll take care of this. And I hear this all the time with people who fall in a parking lot, or they fall on a sidewalk, or even if they fall in a restaurant, the owner or the manager will come in and say, don't worry, we're going to take care of this. And then when they go to the hospital, they say, I slipped and fell at this location, and they said that they're going to take care of it. Here's the problem with that. The owner or the manager is typically not the person that's going to make the decision as to whether or not they're going to take care of it. They have to turn it over to their insurance company. When you have insurance, you have a contractual relationship with the insurance company. Part of that contractual relationship is that you have to notify them of any potential claim, and then you have to follow what they tell you to do. Well, when you notify the insurance company of any potential claim, they're going to go through their process, and they're going to look at the law and determine whether or not you have any liability, you have any exposure, and they're going to make their own decision as to whether or not they're going to pay. So even if the owner or manager of the business thinks that the business should, in fact, pay for somebody's medical bills, the insurance company is going to be the one that makes that decision. If you go to the hospital and say, these people said that they were going to pay my medical bills, the hospital's going to want to bill that individual directly because they don't have to bill them at the discounted rate. When you go to the hospital, if you have like Blue Cross Blue Shield has negotiated a discounted rate with that hospital and with every hospital, which will be much cheaper than the private pay rate. So they're going to bill that company where you fell and not bill your insurance. The problem is if the company doesn't pay, you're going to be personally on the hook for that bill. And it's going to be at the private pay rate, so it's going to be significantly higher. Here's where it really gets bad. Medicare. So somebody gets out of a vehicle, they're elderly, they slip and fall. The manager of the store or the owner comes out and says, I'm so sorry, we'll take care of your medical bills. They go to the hospital. They tell the hospital that. The hospital bills the store. The store doesn't pay. Nobody pays attention, and a year goes by. Well, now the hospital cannot bill Medicare. Same would happen with your private insurance. If a year goes by, now you can't bill them. So now this elderly person is on the hook for this bill, and they're on fixed income, and they can't take care of it. If you're ever in any type of incident, wreck, fall, whatever, when you go to the hospital, your indication to them is, I want my health insurance billed. That's who you want billed for all of your medical bills, no matter what happens, no matter how you incurred them. Let your health insurance pay for them. Then your health insurance can get reimbursed if there is a claim. There's rules and regulations with regards to that, and they're designed to protect you and make sure that you, in fact, get everything taken care of. But you want those bills paid, and you want them paid by your health insurance. There's other reasons to do that, but just understand, Number one, if you slip and fall, if it's a natural accumulation, they don't have any liability for the most part. Okay, that's in Illinois, but generally speaking, that's the rule. If they go to try to remove snow, then they got to do it in a reasonable manner. You should always talk to a lawyer about this. But when you go to the hospital, tell them you want your health insurance billed. You can't control that. They get to make their decision. If they decide not to bill your health insurance, you need to involve your lawyer right away. And what your lawyer should do is send a letter to the hospital saying, okay, you can do this, but if you don't get paid, then you're not going to bill this person individually. If you want to get paid, you should bill their health insurance, and your lawyer should be able to resolve that. I hope everybody has a great Wednesday. This is my Tuesday tip coming a little bit late. This one went enough time. So later this week, I'll do my constitutional one. I started doing constitutional questions. There's good constitutional stuff out there. I thought maybe we might talk about the Electoral College. I think that'd be a good one. So in a couple of days, I'll do a little bit of something on the Electoral College. Thanks and have a great day.